Culleton.
Mr President, just one question.
Order on both sides.
To the Senator, the Honourable George Brandis.
Just a moment. Order on both sides. Senator Culleton, start again.
Thank you, Mr President. One question to the Senator, the Honourable George Brandis, QC Attorney General and Leader of the Government in the Senate. Since Senate School, it has come to my attention that there is a discrepancy between Section 33 of the High Court Act 1979, which says that all process shall, which means must, be issued in the name of the Queen, and the High Court rules of 2004. If this appears to be the case, why has the High Court felt free to defy the Parliament for 12 years?
The Leader of the Government in the Senate, the Attorney-General, Senator Brandis.
Well, thank you. Thank you, Senator Culleton. Congratulations on your inaugural question in this chamber. I must confess, Senator Culleton, I wasn't expecting to be asked about the High Court rules, an object of some fascination to me, I might say.
On my left.
I will have a look at Section 33 of the High Court Act and whether or not it is apparent that there is an inconsistency, as you say, between Section 33 of the Act and the rules made under the High Court Act. As you would be aware, Senator Culleton, the rules of court are procedural rules. They attach forms, usually, that are used in the process of the court and the various procedural steps in proceedings before the court. I must confess it's never been drawn to my attention before that there may be an issue about the consistency between the High Court rules and Section 33 of the Act, but as I say, I'll look at the matter.
Thank you, Attorney General. No supplementary, Senator Culleton.
Questions be placed on notice. Mr President, I have some further information in response to a question asked of me on Monday by Senator Culleton. Senator Culleton, in his question to me on Monday, pointed to what he said was an apparent discrepancy between the requirement in Section 33 of the High Court of Australia Act that all process shall be issued in the name of the Queen and the High Court Rules 2004. I undertook to have a look at the issue, and I did. And having looked at the issue, through my department, I drew the matter to the attention of the Principal Registrar of the High Court, Mr Andrew Phelan. Mr Phelan has responded, and he has advised that the High Court's Rules Committee wants to have a look at the question, and that will probably take place at the next meeting of the High Court's Rules Committee in October. If I may say so, Senator Culleton, it is very, very unusual, if not unprecedented, for a senator's question to find its way onto the agenda of the Rules Committee of the High Court of Australia, and I'm sure it is utterly unprecedented for a senator's inaugural question to do so. Thank you, Senator Culleton.
Thank you, Senator Brandis.
Silence, all stand. Please be seated.
Senator Culleton.
Mr President, my question is to the Attorney-General, Senator Brandis. I refer the Attorney-General to my question without notice on the 12th of September 2016 regarding Section 33 of the High Court Act and the High Court Rules 2004 and my concerns about the High Court of Australia generally. In light of the Attorney-General's response to my question, which he tabled in the Senate yesterday, can the Attorney please explain to the Senate how the High Court intends to deal with the issues I've raised?
The Leader of the Government in the Senate, the Attorney-General, Senator Brandis.
Well, Senator Culleton, it's not for me to speak on behalf of the High Court, but I can tell you that after your question, I did raise the matter with the Principal Registrar and CEO of the High Court, Mr Phelan. Mr Phelan has responded to me in a form which I have his authority to read to you. He said, an exposure draft of the High Court Rules 2004 was circulated in April 2004. The exposure draft was the subject of detailed comments by the Law Council of Australia, the Australian Bar Association and the Special Committee of Solicitors General. After considering those comments, the Justices made the High Court Rules 2004 on the 5th of October 2004. They were tabled in the Parliament on the 16th of November 2004 and came into effect on the 1st of January 2005. No issue was raised in the process of drafting or consulting concerning the consistency of the rules with Section 33 of the High Court of Australia Act 1979. The Rules Committee of the High Court considered that issue on the 12th of October 2016. The committee proposes a number of amendments to the rules to address the issue. The proposed amendments will be drafted by the Office of Parliamentary Counsel and will be the subject of consultation with professional bodies before being finalised by the court. Now, Senator Culleton, it was you who spotted this discrepancy. It was you who spotted the discrepancy in the High Court rules, which the High Court Rules Committee has now acted upon. I might say, since those rules were promulgated in 2004, there have been 16 distinguished Australian jurists sit on the High Court, including 2 Chief Justices. And I must congratulate you, Senator Culleton, on being the first person to spot the problem.
Thank you, Attorney-General. Senator Culleton, supplementary question.
Given what the Constitution provides in Chapter 3, Section 72 regarding the removal of judges, how is it possible to address the now proven misbehaviour by simple amendment without first addressing the original breach of the Constitution by the High Court of Australia in failing to take the changes effected by the High Court of Australia Act to referendum?
Attorney-General.
Oh, well, Senator Culleton, I have to correct you with respect. There's certainly no breach of the Constitution. There is no requirement that what we're talking about here is a discrepancy that you have identified between the High Court Rules 2004 and the forms to the High Court Rules. Now, that's not a constitutional issue. It's an issue that is entirely able to be corrected by the amendments to the rules that are now in contemplation following your question. There is no issue of constitutional invalidity or indeed no constitutional issue raised here whatsoever.
Thank you, Attorney. Senator Culleton, final supplementary question.
Thank you. Given my question concerns the issue of the past and present deliberations of the same High Court of Australia, while this misbehaviour remains unaddressed, can the Attorney-General advise whether the High Court must stand down until such times as the matters under investigation are clarified and resolved?
Attorney-General.
Well, Senator Culleton, you really shouldn't accuse the judges of the High Court of misbehaviour. There is absolutely no suggestion of that, and it's not a proper thing to do. It appears that a mistake was made in 2004 in the drafting of the High Court rules, a technical mistake, a mistake of a very technical nature, so that there was a small discrepancy between a form and a rule. That is not legally consequential. It is not legally consequential. In fact, no member of the current High Court was a member of the High Court of Australia in 2004, so no member of the High Court was involved, of the current High Court, was involved in the decisions made in 2004. No member of the High Court has been guilty of misbehaviour. No member of the High Court has been guilty of any unconstitutional conduct. This is not a constitutional issue. It's not an issue of behaviour. It's a question of a minor discrepancy, which you, Senator Culleton, have noticed.
Thank you, Attorney General. The time for answering the question.
Silence, all stand. The High Court of Australia is now in session. God save the Queen. Please be seated. Silence, all stand. The Court of Disputed Returns is now in session. God save the Queen. Please be seated.